Welcome to Court Helicopter News. My name is Martina Swiga. I am an advocate of the High Court of Kenya. On today's explainer, I would wish to discuss about contracts. What are the things you look at when you're dealing with a contract? And what are some of the most important or salient features that you need to take that you need to give more attention to, especially if you do not have a legal advisor or a legal counsel to review your contract. Or foremost important, I wish to inform you that every contract is a negotiation. Even if they say there will be no negotiation on this contract, every contract is capable of negotiation. It just depends with your tone and how you wish to approach the person who gave you the contract. And it helps a lot if you have a legal counsel, because they will know how best to indulge the other party so as to revise the contract to be to the specification of to be the specification of what will be of benefit to you. So contracts are very many, and honestly, the importance of any clause depends on what type of contract it is. Is it an insurance contract? Is it a construction contract? Is it an employment contract? Is it an intellectual property contract? What kind of contract is it? That is the one that will inform you what exactly you're looking for. And if it is a commercial contract. So all of them have different clauses, but I will touch on the clauses that cut across all contracts that exist in almost every contract, so that you can just be able to focus on that if you're not able to find legal representation. But always I advise that it is important for you to incur the cost of a legal representative, other than waiting until shit hits the fan, and then that's when you're looking for a lawyer to help you on something that you would have involved them from the onset, and it becomes even more expensive at the end. Anyway, so there are some elements of a contract that must exist first and foremost before it becomes binding. And a contract does not need to be in an A4 foolscap or a binded document. It doesn't need to be serious. An agreement is whereby two people agree, and there was an offer, one person offers, and this offer is met with an acceptance. There's a consideration, and then that becomes a contract. So it can even be literally on a piece of paper or even on a piece of a serviette. That is binding, as long as whatever the subject of the contract is has a legality. You cannot have an enforceable contract with something that is an illegality. So there must be legality of purpose for the contract. So I wish to rush through a few of the clauses. One of the most important ones, and I'm not listing them in order of importance, I'm just going to mention a few. We have the dispute resolution clause. A dispute resolution clause is a clause that anticipates when the two parties may have disputes. Normally, when you enter into a contract with someone, of course, you're not expecting to get into any dispute, but disputes are very normal, and therefore it is very important for your contract to have a dispute resolution mechanism. The dispute resolution mechanism may say that the parties will negotiate, or they'll have a mediator, or the dispute will be subject to an arbitration or court. So it depends on the parties, and it depends on the person giving the contract, how they wish the dispute to be resolved. And if you negotiate, you can always avoid court by saying that the dispute can be handled by negotiations or by a mediator, any other alternative dispute mechanism, dispute resolution mechanism that does not necessarily involve a court of law. Because as we all know, the wheels of justice in this country, they grind very slowly. So you might go to court and stay in court for a while. Another important clause is the governing law. For instance, you're given a contract by a party that is not in Kenya. What is the law that will govern this contract? Is it the laws that apply in Kenya, or the laws that apply in the country that this contract emanates from? For example, Uganda or South Africa or the United States. So it's important for you to submit to the governing law that you're familiar with. And if the contract is being enforced in Kenya, it is better that the governing laws are the ones that govern Kenya. If the contract is being enforced in South Africa, it is then important that the governing laws as per the contract be South Africa, so that in the event of any dispute, then the laws within that jurisdiction are able to help you. Another important clause is a clause as lawyers call force majeure. Force majeure is where a party is indemnified for acts that are beyond their control, which acts make it hard for them to enforce this contract. For example, force majeure are things that we cannot anticipate as human beings. You do your best, but you cannot anticipate if maandamano will take place that is beyond you. We also call them acts of God. For example, if a tree falls, or COVID, or a pandemic, all these things that are external forces other than you that will make it difficult for you to enforce this contract. It is a very important clause to exist because it protects you and you will not be liable in the event an act of God happens. It is only fair that you're indemnified from the performance of the contract or the agreements. Good. Another very important clause that people tend to forget is the termination clause. It is very important to have a termination clause, which states or gives the provisions of how your engagement with this other party is going to be terminated. Is it 1 week notice? Is it immediately after performance? Is it what are the terms of termination? But it is very important that a contract spells out termination. It needs not be long, but it has to be there. It is a salient feature of a contract, and it is very important for it to exist in a contract. I wish to delve into intellectual property in a contract. So depending on the kind of contract you have, for instance, you are a creative or you're creating something that is subject to copyright or trademark. The intellectual property clause is very important because that clause will tell you whether whatever you're creating will belong to you, or it already belongs to you, or it belongs to another. So it is very important for you to understand the different areas of intellectual property and what it covers. And I think I will delve into that on my next explainer. But it then shows what kind of rights will ensue from the contract in the event, for example, you work for a media company and you write an article, a groundbreaking article. Perhaps your contract tells you that any article you write during the subsistence of this contract belongs to Nation Media. So you then cannot come and claim that, oh, this is my article, because your intellectual property clause in your contract informs you that whatever it is you're creating during the period you have that contract belongs then to the organization. But that does not mean there are some intellectual property rights that cannot be okay, they can be violated, but they cannot be derogated. For instance, what we call the moral right, the right to be named. If you wrote that article, even if the contents then belong to the organization, you have the right to the name of that article. If it was written by Martina Swiga, then that name will continue to exist. So moral rights cannot be derogated, and you will still maintain them even if the intellectual property rights, whatever you're creating, forms as a license to the party you're contracting with. Another clause that I've seen recurring here and there, especially with employment contracts or commercial contracts, is a non-compete clause. A non-compete clause essentially tells you that you cannot compete against the subject of the contract within a specific period of time. For instance, you are skilled at doing a particular job and you're employed because of that skill. And then they tell you in the contract that even after you leave this work, within the next 6 months after your termination, you cannot do anything similar to the subject matter. And that is subject to the kind of contract it is. And out of an abundance of caution, I always urge my listeners to always involve a legal mind or a legal representative, so as to understand, because the way we use words as legal practitioners, they have meaning, they have a lot of interpretation, and you might just see a word and assume it, thinking it is the normal meaning, while it has a totally different meaning in the legal space. So it is always better to prevention is better than cure, and it is easier for you to approach a lawyer at the onset, other than approaching a lawyer when everything has fallen, has not gone through, and then now you're trying to collect the pieces. So that is it from me. Thank you very much for listening, and I will see you next time. Thank you.